I should state on the record, the assistant prosecutor who appeared before Your Honor had absolutely no authority to enter into this type of plea arrangement.
So if that's the case, does the people's offer remain the same?
Yes, Your Honor.
Just that a unicorn of an outlier that was the product of what appears to be now a rogue agent. And so your motion is denied. We will proceed forward with sentencing. Mr. Spencer, did you talk to Mr. Abood? Are they ready to go on, Mr. Abood? You're muted, by the way, Mr. Spencer.
My apologies, Your Honor. I think I have spoke to Mr. Abood, and I think we're going to try to get a moment to speak with you if we can.
Mr. Spencer, we're just going to wait. I guess I probably should check in with, if we're about to conduct a 2-witness hearing, why don't you jump into the breakout room with Mr. Abood, and I can figure out what's going on there. Mr. Spencer, I'm going to run back to my chambers, log in from there, and then jump into the breakout room with you, Mr. Abood, right?
Thank you, Your Honor.
Okay, calling case number 26-00463, Jacob Malouf.
Good afternoon, Your Honor. Bob Spencer from people.
Good afternoon, Judge Jeffrey Abood, on behalf of Mr. Malouf, who is present via Zoom video. Also present is my associate, Angela Kaminsky.
All right, today's date and time set for pretrial. We had some brief discussions. There are certainly a number of complicating factors related to this case. I just wanted to see where we're at, Mr. Abood, Ms. Kaminsky.
Judge, we spoke to my client in a breakout room, and he is prepared to move forward today with entering the plea as we had discussed.
So, Mr. Spencer, do you want to put your plea bargain on the record?
Yeah, Your Honor, I just want to clear up with Mr. Abood first. We discussed that there was a mention of people having offered allowance, and that was actually a little bit below what I originally anticipated offering.
Sorry, I don't mean to cut you out. I apologize. I'm having a really hard time hearing or understanding exactly what you're saying. I don't know if it's my audio but it looks.
Can you hear me okay?
I can hear you, Judge. I hear you perfect.
Okay. So, Mr. Spencer, it's my understanding when we broke that you were going to offer an allowing an intoxicated person to drive. Counts 1 and 2 would be dismissed, and there was discussion about a potential sobriety court. It's become clear that it would be probably a better fit for a regular probation with the full terms of operating while intoxicated, just without the charge. I would follow that request. He would be beholden to the court for a probation that was in the style of OWI. So I think he and Mr. Abood and Ms. Kaminsky are aware of that. So at the time of sentencing, they wouldn't be walking in saying, hey, it's allowing an intoxicated person to drive. Why do we have all these conditions? I think everybody's going into this with eyes wide open, that as a part of the major reduction, that the probationary term would look and feel like an operating while impaired or operating while intoxicated probation. So if that's the case, does the people's offer remain the same?
Yes, Your Honor. Thank you for being so decisive.
Mr. Abood, is that consistent with what we all talked about?
Yes, thank you, Judge.
You're pleading guilty to allowing intoxicated person to drive, which is a misdemeanor, carrying with it a maximum possible fine of $500 plus costs and up to 93 days in jail, all at this court's discretion. To plead, you know what, we might as well make this a no contest plea, so I'll just use the police report.
Thank you.
Lack of memory, does that make sense, Mr. Abood?
Thank you, Judge.
All right, so the reason I'm reviewing it this way is because there's not a true, there's not a factual basis that I can elicit from your client that would really fit the reduced charge. So what I agree, I could take the factual basis from the police report for the higher charge, but just accept the plea on the lower charge.
Correct. I was going to ask if we could put the elements of allowing an intoxicated driver for purposes of the plea, but I don't know that the court would be willing to do that in this particular case.
I think just simply making a record saying I've reviewed the police report, there's a sufficient factual basis for the underlying offense, so I will accept the plea on the reduced offense. Case law has supported that. That even if one might look at it and say it could be in essence a legal fiction, as long as there's a factual basis for the underlying charge, the court can accept a plea for the reduced charge in this case. With
Right.
that, I'm satisfied as long as both counsel are satisfied.
People are satisfied.
Mr. Aboud,
Okay.
satisfied?
Yes, Judge, defense satisfied.
I'm also going to set it for a bond violation hearing at the sentencing to deal with a positive test on June 15th. I'm not going to address it today because I want you and Mr. Aboud to put together whatever information. There might be an explanation for it. I've noticed that there hasn't been any positive tests since. So it might be something that is easily explained. That's why I'm not addressing it today. I'm giving Mr. Aboud and Ms. Kaminsky a chance to provide to me the documentation that might explain what happened on the 15th. Okay?
Thank you, Judge. Judge, if I may briefly, I just, and I know you're in the middle of another hearing, but just a couple quick questions for my client, if that's okay.
Go ahead.
Okay. Mr. Maloof, you understand that we had an opportunity to talk obviously prior to today with the offer, and then again today after the offer and after we pre-tried the matter with the prosecutor. Is that correct?
Yes, sir.
Okay. And we explained to you that we can't make any promises or guarantees or anything regarding how this could affect your employment. Is that correct?
That is correct.
And you were given an opportunity to be able to consult with your employer if you so wish to do so. Is that correct?
That is correct.
Okay, but you still want to proceed with the plea as stated on the record today, as opposed to consulting one more time with your employer?
Yes, that is correct.
Very good. I think we've completed the record here. My staff will be in touch with you, Mr. Aboud, Ms. Kaminsky, and Mr. Maloof, and we'll get to the business of moving forward. Thank you all.
Thank you, Judge. Thank you, Mr. Spencer.
Thank you, Your Honor.
All right. All right. The record should also reflect that we have Lieutenant Hatfield from Berkeley Public Safety, who's also present for this hearing. Mr. Hall, this is your motion, your office's motion. Go ahead.
Thank you, Your Honor. Obviously, the court has read our motion. I would like to add a couple things that the people were unaware of at the time that this plea negotiation happened. I'm aware that there was a pretrial services report where the defendant missed a test on 6/14. I believe that the court indicated in the plea that you were going to deal with the positive test at the time of sentencing. So I can't speak to that. I do know that the defendant had dilute tests on 5/16, 5/20, 5/29. The people were unaware of those when we entered into the plea negotiations. The plea happened on July 10th. There was another dilute test on 7/15. My belief is when there's a dilute test that it is masking a positive test. Had the people known that, I would assume that we would not have entered into this type of plea. I would also indicate when I read the defendant's response, I'm somewhat skeptical of Mr. Aboud's position that he was unaware that the prosecutor's office didn't enter into this type of negotiation. He represented a client by the name of Kim Sue, and that was in front of Judge Karniak in the 52-3 District Court. The brief that Mr. Aboud filed in the case before, Your Honor, is a mirror of what he filed in that case. During the course of holding a evidentiary hearing, Mr. Aboud brought up the possibility of allowing his client to plead to allowing an unlicensed person, an intoxicated person to drive. Mark Laws was the assistant prosecutor on that case. He originally indicated that he had never even heard of such a thing and that we do not, as an Oakland County Prosecutor's Office, enter into those type of arrangements. And that plea offer by Mr. Aboud was denied. So I'm skeptical that Mr. Aboud had no knowledge that we, as the Oakland County Prosecutor's Office, don't engage in this type of plea agreement. I believe that the plea should be set aside, as it certainly is not in the interest of justice. And I'd leave any further comment for rebuttal.
Judge, first of all, to address Mr. Hall's comment about me saying, or about being skeptical of me not knowing, I have on more than one occasion with the Oakland County Prosecutor's Office entered pleas for clients, defendants in the past of allowing an intoxicated driver to operate a motor vehicle. So that's not the case. In that particular case he referenced was, I think, is inappropriate to reference another case in this that I handled on the record in this matter. In this case, it was negotiated. The assistant prosecutor was handling the matter. It clearly had apparent authority to be able to enter into a plea. The plea had been negotiated after a letter that we sent after we were intending on filing a motion. And I believe the court's well aware of that. We did have a conference with Your Honor prior to even entering into the plea. The offer was made, the offer was accepted, and this would be a gross injustice if the court were to set this aside. First of all, the court rules allow for the defendant to be able to set aside a plea, not for the prosecution. The prosecution, I believe the only way it would be able to do it is if the defendant failed to comply with the terms of the plea agreement. Here, there's no terms of the plea agreement that my client has failed to comply with. Further, there's numerous, and I can go through all the case law and cite it all for you, but it's all listed, I believe, in our response to the motion. But there's not a single case on point. In fact, the only two cases I was aware of where the trial court did allow something similar to this to happen, it was reversed, once by the circuit court, another time by the Court of Appeals. And the law is clearly on my client's side. And I'm actually appalled that the prosecutor's office is spending money, taxpayer money, and as a resident and citizen of Oakland County, I don't know how other people would feel about this as well, but I think it's definitely not a good use of the resources, especially when the law is extremely clear on this. You know, he's revoked his constitutional rights. He had a right to remain silent, and after entering in this plea, there would be a huge prejudice against him if the court were to set it aside and allow him, and then at that point, my client proceed to trial. He's never going to be in the same position again.
I've reviewed both pleadings, and so as far as going into Martinez and the court's familiar with the arguments both sides related to that, but I will take a brief rebuttal from you, Mr. Hall, and then I do want to see the parties at a sidebar briefly, and then go back on the record.
Judge, I really don't have any rebuttal other than the fact I do not believe, because it's a no contest plea, that the defendant is prejudiced in any way. I should state on the record that the purpose for the motion was the fact that the assistant prosecutor who appeared before Your Honor had absolutely no authority to enter into this type of plea arrangement. That is clear in the motion. I did not state it on the record. Thank you.
All right, going back on the record on 26-00463, Jacob Maloof. All right, before we proceeded to the court making its ruling, I did want to make sure that all parties were aware. Obviously, what's happened here was certainly a highly unusual, highly concerning situation related to the conduct of the APA assigned to the case. And before I go forward in making the ruling, I just want to place a couple things on the record. As I would expect from the Oakland County Prosecutor's Office, an investigation, inquiry into the decision-making related to the offer, the purpose of the offer that was made, really understanding the conduct of the APA in question. And the record should reflect that this court did have communication unrelated to the case or any of the merits or any of the facts of the case with David Williams at the prosecutor's office and Mr. Hall. I would absolutely understand and be willing to step aside. Knowing the content of the conversations.
Judge, defense has no objection whatsoever. We appreciate the court. We appreciate the court's candor, honesty, and what we believe the court has been nothing but ethical and followed the law ever since you took the bench.
All right. So this circumstance is frankly one of the more concerning events that I've been a part of when it comes to just the management of my state law docket. What I believe is the appropriate position from the bench, and that is allow prosecutors to be prosecutors, allow defense attorneys to be defense attorneys, and not weigh in other than when parties look for assistance from me or to offer helpful suggestions, but never to weigh in and certainly refuse to accept a plea or anything like that. This case, this circumstance, frankly, has and will certainly affect me going forward. It undercuts the prosecutor and their authority if the bench is always doubting. And all of us have seen judges who waded in, overplayed their hand to the disservice of the management of the case. I I prefer the way that the court has handled it. That's why I've done it the way I have for the last 13 years. I do find that there's now going to be a greater inquiry. Do you have the authority of your office? Did you talk to the OIC? And the reason why I'm going to feel compelled to do that is because of the lack of a real avenue of relief available to the people. If their APA acts under the, what appears to be apparent authority and makes the offer, and the defendant in good faith accepts the offer, and the court accepts the plea, again, I think that the prosecutor made their arguments today in good faith, and that there was certainly an interest of justice sort of approach that was attempting to be applied. But I just don't see within the rules or the case law that the court can unring this bell. And I do agree that the outcome, especially for the investigative agency, would certainly seem to be outrageous to have been shut out of this process and to have this particular outcome. I completely empathize with Lieutenant Hatfield and Berkeley Public Safety, because their hands have been tied. The efforts that they put in have been diminished, certainly from their perspective, by the way in which the case was resolved. I know that in this circumstance, if something happens and an APA goes rogue and doesn't comport with the expectations of the Oakland County Prosecutor's Office or their standards, under the law, there are very limited steps, if any, that can be taken by a court. And so that means, and I'm sorry, Mr. Hall, because I know for your division, they have to deal with me a lot. It means an extra question is going to be asked, and another double check is going to take place that will certainly feel more invasive than the past. But frankly, I think it will protect from this event ever happening again. And the court then made it very clear and gave the APA an out. I listed the exact offer that was made, gave the prosecutor one more chance to take a look at this plea bargain, and there was not only an affirmation, a reaffirmation of the plea bargain, but even thanking the court for clarifying what the offer was, and did not retreat from that position. But I would point out that the people's response should once again affirm the Oakland County Prosecutor's Office commitment to taking drunk driving cases, demonstrates that this case was just that, a unicorn of an outlier that was the product of what appears to be now a rogue agent. And I'm sure that will change policies at the prosecutor's office, as it will change policies for this court accepting pleas. But I just can't find it, Mr. Hall. I can't find a manner in which to justify the relief that you're requesting. I've studied, I've taken a look at the case law, I've scoured the court rules, and I think we are stuck with the result that is here. And so your motion is denied, and we will proceed forward with sentencing. Now,
first, I would like to thank the court on behalf of the Oakland County Prosecutor's Office for acknowledging the fact that we do take drunk driving seriously and making a record of that. That is very important in this instance, that you do recognize, that the court does recognize the seriousness that the prosecutor's office takes.
Based on just really their resources and our sentencing normally being done on Tuesdays, is not normally able to provide a prosecutor at the time of sentencing. But I'm going to set this on a Friday, so we do know that we have an APA here that can be present. And just knowing Mr. Hall and the office, and as well as Lieutenant Hatfield and the Berkeley Public Safety, I certainly want them all to be present to see the way in which, at the very least, even though there were challenges related to the charge, the court still has the ability to monitor Mr. Maloof on probation. And I would want all of you to be able to see the safeguards that are going to be put in place, both to hold Mr. Maloof accountable, but also to put him in the best possible position to never be in front of a court again. And so I will move away from my normal practice of setting this on a Tuesday and instead set this on a Friday so we can guarantee that the people will be there. And it's just a reminder again, Mr. Maloof, of how important it is that you stay in full compliance with your bond conditions. As you can tell, your attorney worked very hard to create the best possible resolution for you. And in doing so, was able to go even beyond what is normally accounted for when it comes to plea bargain offers from the prosecutor. It is then going to be up to you, Mr. Maloof, to demonstrate that you were worthy of this really outside of the norm offer. It's going to be up to you. And ultimately, it will also be up to me to make sure that despite the nature of the charge that you pled to, the court can continue to maintain the safety of the community by holding you accountable and providing a structure where you stay sober. So please do not test this court with any sort of contact with alcohol or bars or anything that would make it suggest that you are violating a bond condition, because that certainly would put jail in play, and you need to be aware of that. Understood?
Yes, Your Honor. Thank you. I totally understand.
All right. Thank you all.
Thank you, Judge.